Welcome to today's webinar. My name is Karen Lacer, and I'm the events manager with Nifty Method, and we are thrilled to have you all with us today. And this is being recorded, just so you know, so sit back and relax. I'm happy and have the pleasure of introducing Russ Riddle. He's joining us again, and some of you may have been on webinars previously when we've had him, but we're happy to have him back. Some of you already know him. For those of you who don't, let me tell you a little bit about him. So what do Barney, the purple dinosaur, Thomas, the tank engine, and as of today, you have in common? All have been served or are about to be by Russ, having practiced marriage for 37 years, law for 29, fatherhood for 28, and braved adventures as a juvenile probation officer and professional speaker. Russ is convinced that we must never stop learning and laughing. His love of levity stems in part from an intellectual property law practice that has served such clients as the aforementioned purple dinosaur, the most famous and useful tank engine Thomas, the voices of Jimmy Neutron, Larry the Cucumber, as well as many NSA characters throughout the country. Russ currently serves on the National Speakers Association Board of Directors and is chair of the editorial committee for Speaker Magazine. He's the author of 2 books, Lawyer Up, The Smart Way, and Persuasive versus Abrasive. The judges have ruled, as well as the intellectual manual, Corral Your Cash Cow, which is why we are all here today. Appropriately known as the anomaly at law, for he's down to earth, clearly communicates and lavishes others with levity. So we are happy to have you back with us today. Today's webinar will be recorded, and an email with that link will be sent out after the webinar. Give us a couple of days on that. It usually takes us a few moments to pull it together, but we will get that to you. To ensure a quality recording, we have muted all the lines, but we do want to hear from you. So please use the chat feature to talk to each other, to talk to us. Myself and my colleague Courtney Martin from Nifty Method is also here. So we will be answering questions and fielding comments and chatting with you guys throughout. We also encourage you to use the Q&A feature. So there's the chat feature, and then there's also a Q&A. Use that to drop in any questions that you would like for Russ to address at the end. And we will save a little time at the end. And if not, we may go over a few minutes just to answer some of those questions, but we want to make sure that you get the content today. And again, all of that will be recorded from beginning to end, so you won't miss anything. So with that, I would like to welcome Russ, and we'll start our recording now. Russ, give me a second to hit record and stop sharing my screen. You are ready to go.
All right. Can everyone see my screen?
Yes.
All right. Glad everyone's here today. I understand we have a variety of attendees. We may have some event planners. We may have some marketing folks, speakers, associations, and all of this is applicable to each of you. And we all have intellectual property. We all have things that we want to protect. And we're going to talk about that today. Today, we'll be talking about the 2 intellectual property types, copyright and trademark. Those are the 2 most common ones that business owners have. Patents deal with inventions. Some of you may have a patent, most of you don't. And so we won't do that today. And time will not permit us to go into trade secret law. That's typically things like the Coca-Cola formula or the KFC, however many herbs and spices recipe. Things that aren't known to the public, they're trade secrets. But today, again, copyright and trademark. So let's get started with that. Well, for some reason, there we go. Okay. Copyright. Everyone tends to interchange the terms copyright and trademark. They're both intellectual property types, but they're not exactly the same. Copyright protects content. So when you think copyright, think content. They both start with C. It's easy to remember that. You've got a silly picture of me popping up out of a Jack-in-the-Box because I want to bust a myth. And I want you to remember that myth about that image. Copyright springs into being the moment it is fixed in a tangible medium of expression. Now that's just legalese for when ink is on paper, or when something is saved in your hard drive, or when something is saved in your video camera, your camera on a a photo card. If it's saved in a tangible medium, copyright's in place. You don't register the copyright with the Copyright Office to create the copyright, but I do want you to register. Well, there's some really good reasons for that. The first one being, if you ever had to file a lawsuit for infringement, I'm not advocating lawsuits, but you may find yourself in that predicament sometime. And to have standing to sue on the body of work that you say was infringed upon, a prerequisite to filing the suit and having standing in the court is that you had it registered with the Copyright Office. So that's a very good reason right there. Other reason, it gives you a great piece of evidence. If someone claims they wrote something, you've got a certificate of copyright that you can show them, and it shows the date. And if you win that lawsuit, you get your attorney's fees reimbursed. And as you might imagine, lawyer fees really clock up in a protracted, time-consuming lawsuit. So that's important. And you can also get statutory damages. And that's important because lawsuits are two phases. Liability, did they infringe? Okay, yes, they infringed. Okay, the second piece is what are your damages? And sometimes it is very hard to quantify how you've been harmed. And so when the legislators wrote the Copyright Act, they knew that. And they built into it some statutory damages. And all you have to do is say, Judge, we'll take those statutory damages. And they get up into the six figures. They're significant. So there's a lot of reasons why you want to register your copyright, but it's not to create it. It's just to avail yourself of those advantages. And hey, registering a copyright is cheap. It's 65 bucks. It's done online. It's very intuitive. And I'll tell you something most lawyers won't tell you. You don't need an attorney to register your copyrights for you. The questions are very intuitive. All you have to do is follow through the prompts, answer the questions, upload a digital form of your work, and pay your $65, and you have filed it for registration. Trademark is much more complicated. I'll have other advice about that when we get to trademarks. But we're starting with copyright because everyone has copyrights. There's a situation I want you to be extremely aware of, because copyright protects creators of what they create. And I will bet that if not all of you, most of you outsource some services, creative services. It may be photography, it may be videography, it could be someone helping you with copy, helping you write a body of work, or it could be illustrators, website designers. If it's creating something and he or she is not your employee, rather they're an independent contractor, they still own the copyright if you haven't buttoned it up doing three things. It has to be in writing. It can't be a handshake deal. There are some types of situations that oral contracts are enforceable with, but not with copyright. Has to be in writing. Even if it's an exchange of emails, that sometimes will do it, but it has to be in writing. The second thing is you want to make sure that you have the work for hire verbiage in there, that you have hired them, you've commissioned them to do this work for hire for your benefit, and the intent is that you will own the copyright, not the independent contractor. And then third, you should have an assignment. And you might say, Russ, if I've got the work for hire in there, why do I need assignment? Just to cut to the chase, because we're short on time, there are only 9 categories of things that qualify under the law as works for hire. And you don't want to be second guessing, okay, does this qualify or not? Just have the work for hire language in there in case it does. And you'll also have the assignment language in there if it doesn't. Either way, you will own the copyright if you have that in writing and it's signed by the contractor. Some of you may be thinking or having what I would call a pucker moment right now. You might be saying, oh, I had such and such situation and I didn't have that. If you will email me, and you're going to get my email information, if you will email me, I will send you a 1-page, what's called certificate of work for hire and assignment, and it backdates to when the contractor worked on it, and it's enforceable. And I'm not going to charge you for that. I'll just send it to you, but you have to ask me. Send me your email. And another thing that I will send you if you're interested, I'll send you a paragraph that is language that you could use for the work for hire and the assignment. Did want to cram all that onto a slide. It would be ridiculously small, but I'll send it to you. You probably have seen it before in contracts, and it doesn't have to be exactly this wording, but substantially that wording. I want you to be very careful and avoid a couple of common mistakes when it comes to creating things that you're using that could get you in a little hot water. One is stock photos. If you've got a web designer, he or she probably has put some photos on there that are supposedly purchased from a stock shop, and they're typically not famous people. They're typically just mundane photos, a couple of people at a conference table, two people having a discussion, the kind of office looking photos. Well, if they didn't properly license them, what I call the Getty Gestapo will find you. And I say that because Getty Images is one such situation, but Getty also owns a lot of the iStock, the off, white labeled stock image sites, if you will, and everything is embedded with code. They will find you, and it won't help to just take it down because you have used it, and they won't care that it was your web designer's fault. It's your website. And so they hold you accountable, and you will have to pay some fees. So be careful about what photos are on your site. I suggest you take your own, because then you know you own the copyright. And if there's people that are identifiable, you can get them to sign a photo release. You're in control. But if it comes from a stock site, make sure you're following the terms and conditions. Another situation is when you take photos on location. It's like, I don't know if there's any hunters that are listening, or maybe you grew up with a dad or someone in your family that hunted. And part of hunting safety is be careful of what's in the background of what you're shooting at. There could be people, there could be a house, there could be livestock, whatever. You don't want to hit those. Same thing when you're talking about commercial use of photos. An example would be you're in Times Square. If you are there and you're just on vacation and you want to take photos and put it on your personal Facebook page, that's fine. That's a personal use of your holiday. But the moment you parlay it into a commercial website, then that's a commercial use. And all those brands in the background, you don't have permission for. So be mindful of what's in the background. You may need to have a consent. And if you can't get the consent, you can Photoshop that out, blur it where it's not identifiable. So you've seen photographs that way, I'm sure. A couple of common mistakes to be mindful of. That's copyright. So let's move to trademark. Trademark protects logos, images, a single word, a tagline, short phrases. Copyright does not protect those. Trademark does. And they arise because you're using them in the marketplace. That's how a trademark comes into being. But I give you this image of the branding because it has roots in branding. It's where we get the word brand. It even goes back to hieroglyphics, and there's quite a history. But I want you to have this image and think brand when you think trademark. Trademarks are a little bit more complicated. I'll get the question. Well, I've got the phrase, those are just words, and I've also got the logo. Which one should I file and why? You might want to file both. Your budget may not allow you to file both at the same time, but here are the various advantages. A word mark gives you broad protection, and it gives you great flexibility in how you put it in your marketing pieces. You can use it in any size font, any type of font, any color of font. You've got a lot of flexibility as long as it's the exact words that you filed. Whereas the logo is a stylized look, and it gains faster distinction in consumers' minds. Think McDonald's. The golden arches is much more distinct than the word McDonald's, though they are both trademarks. The limiting thing with your logo, though, is you have to use it exactly as you file it. And so you can't be changing around the design. And if you file a color one, you have to use those exact colors always to show use in the marketplace. So I always suggest that you file a black and white version of it, not claiming a specific color. Then you can interchange the colors, though you can't change the style. But those are kind of why you might want to file one or both for various reasons. Trademark symbols, I get questions about that. And strategy. You've got to be strategic with your trademarks, much more so than copyright. I'll get the question, do I use the TM or do I use the circle R? You can use the TM if you're using it in the marketplace, regardless of whether you've registered it, because there are what we call common law trademark rights that have arisen by case law. It's pretty limited protection, but you're rightful to use the TM, but you can never use the circle R until you get the registration certificate from the trademark office. And that's not when you file the application. That's months down the line whenever you get the registration certificate, when they have granted registration. There's another symbol, SM. That's just kind of a subcategory of trademark. It stands for service mark. If you're offering only services, no products, you might opt to use the SM, but you can still use the TM if you'd like. 2 reasons to be strategic. I talked about how cheap copyright filings were. They're $65 each. That's not, it's not a pocket change, but it's not cost prohibitive in most cases. Trademarks get quite expensive quite fast. They do. The trademark office charges $350 per trademark, and the words are one trademark and the logo's another. They charge per class $350. They have a couple of different filing levels. One is cheaper, but with the cheaper one, you can't tailor make your description of services, which becomes very important whenever someone is saying that they're taking issue with your trademark. You can distinguish it with the wording. So if you had 2 classes of services, say you have a workshop business, you provide live training, whether it's in person or virtual, that's class 41. If you also have manuals or workbooks or books, white papers, that sort of thing, that's class 16. That's 2 classes. 350 times 2 equals 700. And so forth. There's no volume discount. You just keep adding it up. Quite expensive. So you want to be strategic. But the better reason to be strategic is this. Trademarks are about gaining distinction in the marketplace, setting you apart from others in that same space. And so you want to get distinction. And even if you had all the money to file a bunch of trademarks, why would you? Because if you file dozens of trademarks, you're never going to get distinction in the marketplace, because you're here, you're there, you're yonder. The consumers are going, okay, where is she? What is the main brand? So be strategic with your trademarks. And all trademarks aren't equal. I want you to really spend some time whenever you're thinking about, okay, I need to come up with a trademark, a brand. Maybe some of you already have them, but maybe you're developing one. Trademarks have varying degrees of strength. The stronger ones get distinction faster. The stronger ones get through the process at the trademark office easier. They get registration easier. Let me talk about some of these. Here's some examples. A generic or commonplace phrase is not going to be registrable with the trademark office. Okay, Boomer was tried. They rejected it. Taco Tuesday was tried by LeBron James, a famous person. It was rejected because it is commonplace in their minds. Trademarks are supposed to be source identifiers of goods and services. And if it's an ordinary phrase, it doesn't get there. Descriptive. They will bounce these back sometimes if they say it's merely descriptive. It's not really a brand that stands out. Speakers Are Us would be an example. If you were a speaker bureau and you called yourself Speakers Are Us, they might push back and say that's merely descriptive. We have arguments we could make to disagree with them and to persuade them otherwise, but you want to seek something a little stronger than that. Cold and creamy for an ice cream shop. Just kind of merely descriptive. Where it really starts gaining some strength is suggestive. That might be 88 keys for a piano store, or Airbus for the huge airplanes that particular airline has. It's not a bus. It's like a bus, and then lots of people fit in it. Uh, those will be allowed if they're available. The trademark office, if there's something filed prior to that that is either exactly the same in the same classes of goods and services, or it's not exact, but it's close and would cause confusion in the marketplace, they'll reject it. Otherwise, the suggested mark will get through the process. The best trademarks are either arbitrary or fanciful. Arbitrary, the greatest example is Apple for a computer. That's rather arbitrary, but yet it's a very valuable trademark today. Same thing with Camel for a cigarette. Very arbitrary. So you can think about something like that. It's a very strong mark. If it's available, it'll get through the trademark process fairly easy. But the best ones are the coined words, the fanciful, never before words, Exxon, Kodak, some of those kinds of things that are made up. They didn't exist before. It's doubtful you're going to have a situation where someone has already filed something like it. And B, it's going to get distinction really fast. So think about that. Don't take the shortcuts. This shows that, what I was saying, you can't get the generic and so forth. Bottom line in selecting a mark, don't take that easy way, choosing an obvious mark that consumers will immediately get. That's a marketing mindset, nothing wrong with that. But for trademark, from a legal viewpoint, from the trademark office viewpoint, you don't have the same set of lenses on. You want something that's either fanciful or arbitrary, not something that, oh, that must be a piano store, that must be a donut shop. Don't want that when it comes to the strength of your mark. Focus on creating for long-term distinction. Maybe more money on the front end to develop those kinds of things, the coined words, but guess what? It'll be much less money to register those, because you won't have to argue with the trademark office. Your attorney won't have to at nearly as much. And to defend it, it's so strong and distinctive, it's easy to defend. So more money up front, less on the back end. It's well worth it if you want to have a viable trademark. You need to know something about the trademark office. They're anal. It's a subjective process. They're downright quirky. I'll give you a couple of examples, and these are just two. They reject titles of a single work. They won't, if you have a book that's named something and you want to trademark that same thing in class 16 for books, they'll push it back if that's all you've got. They'll say it's not a brand. It's the title of a single thing. Now, if you have that in a workbook for leaders, in a workbook for mid-managers or whatever, customer service, whatever the topic or the tribe, you could get it. An example of that is Chicken Soup for the Soul. When Hansen and Cantfield first wrote that first book called Chicken Soup for the Soul, they could not have gotten a registration in class 16. Today, yeah, they've got 300 and something titles. So it's Chicken Soup for the Soul for this, Chicken Soup for the Soul for that. And so that's one way to get around this title of a single work. And it's not just books, it could be speeches, workshops. So you want to have a plethora underneath that brand. Another thing is ornamental use. This comes into play with like coffee mugs, t-shirts, caps, other kinds of apparel where the mark is on the face of it. If it's only on the face of it, the trademark office says, no, that's ornamental only. It's not a source indicator where that t-shirt came from. So it's got to be on the label. The sewn in label or a hang tag, that may seem silly, but the trademark office's view is this. You don't look to what's on the object necessarily to where it came from. I mean, there were t-shirt shops where you could go and have any image put on any shirt you like. And that doesn't mean that's where the brand is. But if you have it on that tag, that'll overcome this use. Those are just a couple of examples of how they're being picky. And yes, they are. There's good reasons for it. We won't get into that, but they're looking at it from the consumer's point of view. Would the consumer know that that is a brand? Would the consumer know that this item or service came from that brand? So they're always thinking like that. You probably need an expert to guide you through all these quirks. I want you to be aware of trolls and other kind of trickery because they're out there and they will bite you. I want you to buy a URL first if it's going to match your trademark. Buy the URL first, then file the trademark. Here's why. The trademark filings are all public record, and there are trolls that are looking and they'll go, oh, here's a new trademark application for this word or that 2 words. I wonder if they have a domain yet. If they go to GoDaddy or one of the other domain hosts and check it, and if it's available, they buy it. And then they try to extort you for that URL. So buy the URL, it's very cheap, then file your trademark, and you'll avoid that scenario. You will get, because of that public information from the trademark filing, you will get in snail mail in your US post box, you will get it in letter that looks so official, bogus official looking letters that claim, here, you need to send us this money, this is due, we will take care of this so you can keep your trademark. It's trickery. Don't go for it. Here's some examples. Here's one that's from WTMR. If you were reading that, it sounds very official. It looks official. There's your trademark. You're thinking, trademark office sent this. I got to pay this so I don't lose it. It's not the trademark office. Trademark office will never send you an invoice in snail mail. Never will. They'll send you a registration certificate in snail mail. They might send you a postcard notice of a deadline. They will never send an invoice, a letter such as this. Here's another example. United States Trademark Maintenance Service looks so official. Don't fall for it. Don't pay them. You don't have to. You don't need it. So danger, Will Robinson. Yeah, the trademark office realizes this. Here's a link to the trademark office, part of their site where they list some 70 of these companies. They can't stop them because they're not doing anything illegal. They're doing deceptive practices, but just staying above the line of having liability. Same thing with the World Intellectual Property Organization. They have a site. There's a bunch of those out there. Don't fall for it. So let's talk about, so those are kind of some things to think about, distinguishing your copyrights and your trademarks, what protects what qualifies for what. How do I go about it? Some things to strategize with. Okay, you have them. How are you going to protect them going forward? Give you some things to think about. With your copyrights, ensure your ownership from the outset. That's a callback to those independent contractors. Have it in writing. Have the work for hire language. Have the assignment in it. You and he or you and she can say, yeah, you own it. You commissioned me to do it, but if it's not in writing, it's not enforceable. And relationships sour. And what if that independent contractor then says, you know what? You don't really own it and you can't use it. Stop using it. You don't want to be in that situation. Use copyright notices. Doesn't make you bulletproof, but it informs others, hey, this is copyright protected material. And you've seen those notices. You see one at the bottom of these slides. Circle C, a year, the name of the owner, all rights reserved. That's your typical copyright notice. Now, you don't need both the circle C and the word copyright. That's redundant. That's like saying copyright 2020 or copyright 2021. The circle C symbol is so universally known. Everyone knows what that is. You can use the symbol and you don't need the word, or vice versa. The year is the first year that you published that particular material to the public, that you put it out there in workshops, you put it out there in seminars. That's the first year you did that. Then your name or your company name, wherever you hold ownership of your IP. All rights reserved is no longer really required in this country, but you're probably having a worldwide website, and you may be selling to international people, and they're getting access to you from an international base. You want them to see, because it's a closer call in other countries. I just leave the 3 words on there. So have that in there to inform people. It keeps honest people honest. Thieves are still going to be thieves. Can't help that. We'll enforce against them, but this will help. Register your materials with the Copyright Office. We talked about the advantages, how cheap it is. You can do it yourself. Pursue infringers. Now, I'm not saying haul off and file lawsuits, but I do want you to send cease and desist letters. It can be by an email. And all cease and desist letters aren't necessarily the same. You don't have to start with a nasty one, a sledgehammer lawyer letter. You're just asking them to stop. When I worked with Barney at Hit Entertainment, we had two types of infringers. We had bad people trying to make money off of Barney. We also had fans who were infringers. The fans would just put his image on everything, share everything, and they were technically infringing. We don't want to slam them, but we do need to rein them in. So we would send them a nice letter versus the hard letter. But you need to show that you are policing your copyrights, excuse me. I also want you to do takedown notices if you find these things on social media platforms, and that's where they're popping up a lot. All of the web, Facebook, LinkedIn, Instagram, Twitter, all of those have a takedown process, and you can search on their site. They'll have a page that talks about it. You submit information about it being your trademark or your copyrighted material. Facebook routinely just takes them down. Some of the other social media platforms might want to argue with you a little bit, but you want to show that you're sending ceases and desists. You're doing takedown notices on social media. You're not just letting your property be infringed upon willy-nilly. That could bite you later on if you had to file a lawsuit, because they'd be able to show judge, jury, they do nothing to protect it. And here's evidence they do nothing to protect it. It doesn't look good. All right. Control your content too while you're protecting it. And here's a couple of tips. If it's a video or an audio, stream it. In other words, let them access it on your platform, but don't make it permanently downloadable. Professional hackers can still do it, but average people can't do it if you will stream it and don't give them a device or a function that they can download that to their device. Here's why. Once they download it, you have no control over where it ends up, how many times it's shared, how many times it's viewed. But if you've got it on your platform, you can set how long it can be accessed, how many people can access it. You can set passwords, all of those things. You can turn it off if they're getting out of line with the parameters of the license. You can't do that if they've downloaded it. And another tip, if you've got a business partner who wants to have it on their platform, I advise you to keep it on your platform, because you can't turn off their platform, but you can turn it off if it remains on yours. Control your content. It's your valuable material. Another thing I want you to do is have a boilerplate clause in your contracts, no recording of your session unless advance written consent. And I get pushback sometimes with that, but people saying, but I want them to record it because they're going to give me the raw footage and I can repurpose that and all. Okay, great. If that's what you want to do, and that you can allow for that. But if you don't have this clause in your contract that you send them in advance, the conversation might not happen. And you show up and there's all these cameras and you don't want it in that particular situation to be videotaped. It's a little late, and you're going to have to deal with it on site. So have that in there to have the in advance conversation. You're controlling what happens to your content. Let's go back to trademarks and what some things you can do to actively protect them on an ongoing basis once you get them. Continually use them in commerce. Trademarks are like going to the gym. Use it or lose it. You have to use a trademark in the marketplace, or the trademark will eventually lapse. You won't be able to renew it because you won't be able to show continued use. Continue using it in the marketplace. Register it with the Trademark Office because it gives you so much broader power, a lot more protections, presumed nationwide use, even if you've only been doing it regionally. You've got the Lanham Act, which is the trademark law, gives you lots of protections. But here's the thing. You can't just register it. You've got to file the timely maintenance. filings. In the first 10 years after registration, between the 5th and 6th year, there's a required filing. If you don't, they'll cancel your trademark. And you have to renew a trademark every 10 years. So it's not one and done with trademark. With copyright registrations, a copyright is good for life plus 70 years. There's some other carve outs from that, but if you as an individual create something, it's until you die, and 70 years after that, the copyright's still in place. But that's not true with trademarks. You have to keep up with it. You have to maintain it and make the appropriate filings when they're due. Properly use your trademark as a brand name, not a verb. A couple of the things that are happening right now is Google it. That's an improper use of Google, which is a trademark. But we don't, we do that. We fall into that because we don't say, well, go to on your PC, pull up a search engine of your choice. There's Google, there's all this. Search and see, you'll find. No, we just say Google it, shorthand. But that's harmful to your trademark, and you don't want to allow others to do that with yours. Another one is less Uber. No, that's an improper use of the Uber trademark. We're going to hire a ride. We're going to share a ride. We're going to, it may be Lyft, it might be Uber. You get the point. Don't use it as a verb. Use it only as a trade name. And also don't allow it to be used generically for that particular kind of thing. There have been valuable trademarks lost because they allowed that. Aspirin cannot be trademarked. Bear is a trademark, but not aspirin, because it became generic by everyone using, no matter what brand it was, that pain med. Or a Kleenex. It's not a Kleenex, it's a tissue. It might be a Kleenex brand tissue, it might be a Puffs brand tissue, it might be Walmart's Good Value brand tissue. You get the point. I could give you lots of other examples. So make sure your trademark is being used properly as a brand name, not a verb, and for your branded items, not every other item of that type. Pursue infringers just like with the copyrights. That means the cease and desist. That means the takedown notices. So that's the ongoing ways of protecting your trademark. Now, we could go for days. We have 1 hour total, and that includes Q&A. And here's my information, by the way. I said if you'd email me, I'll send you a couple of things, that verbiage for the work for hire, or if you had a situation in the past that you didn't have it in writing, that certificate of work for hire, I can send you that. But let's continue the conversation. There's so much more to copyright and trademark. We didn't even touch upon really getting into using third-party materials that are copyright protected. That is a whole other session. But I want it to be your turn. I want to allow plenty of time for your Q&A. So I'm going to turn it back to you now, Karen. Feed me some questions from the chat, and we'll start there. And we'll just continue. I don't know how much time we've got, but let's give it all we can.
Well, we actually have quite a bit of time, so I don't, we may end up in some conversation here in the chat. I want people to jump in. And I've got a couple of anonymous ones here. I was chatting with people. We've got definitely some meeting planners in here, some small business owners, some that are doing both at the same time. So I'll just kind of go through, and some of these are kind of related, but we'll address them each one. So the first question that actually came in was, how are photos treated that you purchase or pull from free stock photo sites?
Okay. Yeah, we kind of alluded to those free stock photo sites. You have to be very, very careful because you have to read the fine print. You have to read the terms and conditions. Don't always be fooled by the category it falls under. Royalty free is a common category, but with some of the stock houses, that doesn't mean scot-free. It means royalty free. Royalties are back end type of payments as opposed to a front end license fee. And most of those, I shouldn't say most, a lot of the so-called free royalty images, there's a negligible upfront license fee. So be careful. But to answer the broad question of how they can be used, they can only be used in the parameters of the terms and conditions. Even if you pay for a premium photo, pay their price for it. If you get outside of the terms and conditions and they come with the image and are on the site, then you're outside of the license. And regardless that you paid that, you're still infringing. So you have to put a lot into account. That's why I suggest, if you can, take your own photos. If you need something of two people conversing, you can do that. Hey, iPhone photos are okay in a lot of cases. Uh, so that would be the copyright concern. You also have to be mindful of, as we talked about, if someone's identifiable, getting a release of their publicity rights of their image. Also, that background we talked about. But you're
Mhm.
much better off taking your own photos. I know that's not always possible, but read the fine print
Okay,
always.
great. So we have a lot of Canva folks in here. We love Canva. I'm obsessed with it myself. So with Canva, and I know that, this affects folks, especially out, I mean, at Nifty Method, we use it quite a bit. Small business, we do a lot of our own stuff. It's wonderful. I'm assuming it's kind of the same answer with that. So there are folks
Yeah,
that they allow you to have in Canva, and you create, you end up creating something from it, but you are using those
yeah,
they have. So,
yeah. They're giving you permission in advance by their terms and conditions, and you just have to follow the rules.
right,
You can't just take it and do whatever you want to with it.
right. Yep. Um, Here's a good one. Can you talk about how getting either copyright or trademark, how that works internationally? So there's a two-part question here. There's, if you're copywriting, trademarking here in the US for whatever, does that cover you internationally? And then vice versa, if you're doing work for someone internationally, let's say they're international, do you file here? Do you file there? How does all of that work?
Okay. Short answer is no. There's not an international copyright or one doesn't work worldwide. It is by country. That's the short answer. With copyright, however, there's this thing called the Berne Convention, and it's a treaty of sorts. And members that are part of that treaty, and there's a couple of others, if those countries are part of that treaty,
Mm-hmm.
then we can have a copyright here in the United States, and those member countries will defer to our trademark laws. It's not that it's copyright registered in their country, but they will defer to our laws for enforcement.
Right.
That's copyright. There's no such akin to that with trademarks. So if you're doing business in other countries, actively seeking to sell goods or services in other countries, you probably want to register in the major market countries that you are filing in. And there's a way to file one application and it will be applied to different countries, but each country will pass or register it or not in their own country according to their own laws. But it's a country by country thing is the short answer.
Okay.
You may not need a trademark in a foreign country. You sell one-off thing here or there.
Right.
Just depends on the business model that you have, how big a business you have. It gets expensive. Trademarks are expensive here in the United States, and it just is exponential when you start trying to protect in all kinds of different countries.
Right.
But I hope that that's given you enough to think about it. There's a whole lot more we could talk about, but just don't have the time.
Sure. Um, One of the small business owners asked, is there anything in business that people think or companies think that they need to trademark that people try to that you just can't do? So, you had talked a little bit about what you need to trademark. What are some things to avoid, or what's over?
Well, yeah, I mean, first avoid those just generic, common phrase kind of things. The trademark office is not going to register those, and they're not going to gain distinction in the marketplace, which is your goal, because everybody uses those phrases.
Mhm.
But the other thing you need to think about, so think about that continuum that I talked about. The fanciful coined new words is best, or an arbitrary a word for something are best. Uh, you want to be clever with your trademarks. uh, because it's stronger, more enforceable, and all of that. Another thing that people fall into is they'll have a phrase that they like, they use it in things, but they're not using it in a brand way. You
Mhm.
can't get a trademark registered with the trademark office just because it's a phrase that you use a lot. It has to be used in a brand way, which means it is a source indicator underneath which brand goods or services are offered. So, just using the phrase just in your everyday business doesn't do that. But if you have it and underneath that brand, you then say, here's what we offer, then you're using it in the source indicator way, then you can hopefully get it registered. But that's a couple of things to think about. It's not just a clever phrase. You have to use it in the right way.
Yeah, we're always teasing that, the best name in the world right now with Karen. So I refer to myself as the nice Karen. So Lindsay and I were teasing we were going to trademark that and start using it under Nifty Method as that we have the nice Karen
Yeah.
belong
And,
to us.
and I'll just address that real quick in case you're curious. Names names technically can be trademarked. Now, no, Karen could not,
You're right.
but whole name can be.
Right.
I'll give you an example. Uh, oh, let's see, is it John Maxwell? He has John Maxwell trademarked in certain scenarios, certain classes of goods and services. Even John Maxwell couldn't have done just uh, John. Same thing, Tony Robbins has a couple, but he couldn't, even as famous as he is, couldn't use Tony. There's only a very narrow, finite category of people who can use one name and get it trademarked. And those are people like Beyonce,
Right.
Cher, Elvis,
Right.
Karen and Russ and Bob and John and Sue and Shelley doesn't do it.
Yeah. The
So
nice Karen might work though. I don't know if
it
someone's
might,
name.
it might.
Okay, I've actually got some other questions coming in here. This is good. So this is someone else had written in here about the poor man's copyright, but I'm going to read the question here that came in from Daniel. I'm in Canada and was told that if I mail myself my materials, that works for copyright as it goes through the U.S. Postal Service. So now a date stamp issued by a government agency. Thoughts on that?
That's an old myth. It's been around. It was the songwriters would do that and all that. Yeah, it has this much probative value. They won't. They're going to scoff at it as a piece of proof that's been around. A lot of people perpetuate that myth, but that's why registering with the Copyright Office and as a Canadian, you can do that. If you're putting out materials in the United States, you can register a United States copyright. Uh, and you'll answer where you reside and all of that, but you can do that if it doesn't matter that you're Canadian. But no, the poor man's postal stamp copyright, don't rely on it. It's going to get you about here to the curb. It's not get you very far.
You're right. It's a good question though.
Oh yeah,
Yeah,
it's a common myth. Yeah.
right. Another question here. Any resources for avoiding using trademark items? I once tried to theme a conference with a phrase that the client's legal team rejected because it was too close to a trademark phrase, one that Disney used.
Yeah, you can go to uspto.gov, gov, short for government. USPTO
I'm going to put it in the chat.
Yeah, it stands for United States Patent Trademark Office, uspto.gov. And they have a database that you can search. And you can just do a basic word search and you can maybe find any issues there. Also, search on Google and see what else is out there because there may be unregistered trademarks that are trademarks nonetheless, more narrowly protected, but are out there. So do a little due diligence. I would do at a minimum those two searches, the trademark site database and a search on Google or another search engine online.
Okay.
And bear in mind, it's not just exact matches. It could be a close iteration and still pose a likelihood of confusion because consumers tend to remember part of a phrase. maybe
Right.
not the whole thing. And it could be something that, yeah, if you looked at them side by side, you could see there's a slight difference in the two. But if they're in the same kinds of goods and services, that will still be rejected. It'll pose a likelihood of confusion, even though it's a little different.
Right. So if you wanted to say, seriously, just do it, that might not work because just do it's already taken.
Right. Well, it's certainly if you were in class, 25 apparel, trying to put out shoes under
Yeah.
that brand, it would certainly pose a likelihood of confusion. Now,
Yeah.
if you were to seriously just do it, and it was about uh, diets and weight reductions products or something, you could probably get away with it because that's very different than Nike's products.
Now,
But
would Nike be able to trademark that as a new, just adding on to what they've already, just do it belongs to them? Would they be?
they probably could because they already have the just
Right.
do it. You
Right.
or I, even aside from Nike being a problem, you and
Right.
I probably couldn't because it's so commonly
Right.
used.
Right.
But they've established a secondary meaning in the marketplace. When you
Sure.
see just do it, you think Nike.
Exactly. All righty. Let's see. This question came early, actually. Why should I register my work if copyright protection is automatic?
Because go back to the what's your proof? What's your proof that you did that in 2010?
Right.
You could rely on that. The other question, the mailing it to yourself. Okay, that's not going to be a great amount of proof. But if you filed it with the trademark office, the copyright office, not only do you get the certificate of registration, you have to upload a digital version of the work, and the Library of Congress has it. And so you not only can show them the certificate, you could say, look, we can go to the Library of Congress. We could pull that up if you want to litigate this, but I could show you beyond any kind of doubt that I had that in 2010. So it's very strong evidence. The other thing is what I talked about whenever I was saying why register is if you ever have to sue for infringement of that piece, the court will dismiss your case if you haven't registered that with the
Right.
copyright office. I'm sorry, misspeaking. So there's good reason to register it. You're
Better to be
right.
safe than sorry.
Yeah, and it's just $65. You get
Yeah.
so much bang for your buck.
Exactly. Okay. Actually, I have two questions here so far. I don't know if I'll have some more come in, but one is, let's see, what's the difference? They said they know what a registered trademark is. What's the difference between registered and unregistered?
Well, an unregistered trademark is one that you're using in the marketplace as identifying whatever it is you're selling, goods or services. But since you haven't registered it, you don't have benefit of the nationwide presumption and all of the rights that the Lanham Act, the Trademark Act, give you. You have to rely on case law, and with it common law trademark, part of it is it's narrow in scope to you have to show geographically exactly what markets that you have used it in, and your protection only extends that wide. Now that may be a little easier to have a wider swath now that we are having worldwide websites, but before the internet, it was tough. You had to show that you were in that market,
Right.
whereas you had it registered, it's presumed you were in that market if it was in the United States.
Gotcha. All right. This is interesting. Do you have to copyright apps or proprietary software that you create for your business? Or is it a good idea?
Okay, you cut out on part of the question. It's
Oh, I'm
something about
sorry. Let's try
copywriting
that.
software. Say it again.
Copyright either mobile apps, anything that you create in-house, either your own proprietary mobile app or one that you've put together, or software. Is that something you
Right.
need to do, should do, you
Well,
recommend?
remember, whenever it's fixed in a tangible medium, the copyright's in place. So I think that your question is about registering it.
Probably, yeah.
Yeah, yes, you can register those things to the extent that you have created something. part of when you register a copyright, there's a question that says, is there any pre-existing parts of this that you didn't own? And commonly with writing software, there's shareware, which is, a bit of code that anyone can use. It's a basic thing that you could put it. You'd have to disclaim that part of it. But yeah, it's a creative thing that you have put together and fixed in a tangible medium. And so it can be registered as copyright, but you probably have some bits of it that you have to disclaim. The thing about copyright, again, is you're going to be uploading or filing. If you can't be uploaded, it has to be snail mailed. So you're going to have a public record of that code. So you may, or may or may not. There's a whole big issue in the patent office about if software is patentable or not, which we didn't talk about patents, but some people are opting not to do it because it becomes a public record. And others can have access to it. Of course, thieves can reverse engineer and do all those evil things anyway.
Right.
But yes, to answer the question, you can register that copyright.
Okay, and I actually had one other kind of like a comment, but a question in here. It says, I created a company that already had a trademark registered to a series of books that I was unaware of and started doing business. What quick action should I take in all of my branding and marketing so that I don't get sued? I mean, that's kind of a broad
Well,
thing.
I've got to make some assumptions, and you've got my email, so you can reach out to me individually. But if you're in the book, I heard it was a series of books.
A series of books.
Yeah, if you are in that same business, in other words, you're a book publisher or you're putting out books under that same brand, you need to take some steps. If you're, like I was talking about in other scenarios earlier, if you're not in the book business, if you're in the skincare products business, it may not be an issue. So it depends on if it's close, identical enough to be confused.
I'm getting the impression that they're not related. It might be like a clothing line or something. So they're apparel. They're curious what should the steps be other than getting in touch with you.
Yeah, specifically to answer it, I would have to know, I could give you an opinion about whether it's an issue or not. It might not even be an issue because you're in different market spaces, different kinds of goods.
I would say to contact Russ and see what to do next.
Yeah. I would say that, the best thing is if you're going to have confusion in the marketplace, you might want to change it just for that reason. Setting aside getting in trouble with the other party, you might just want to just go back to the drawing board, if you will, and come up with an even better trademark. But what you could do, it's called a coexistence agreement. You can reach out to the person and say, look, you're in the book business. I didn't know about your brand, but I'm not in the book business, but I'm in the yada yada business. And I don't think we have the same prospective consumers. I don't think there's a likelihood of confusion in the marketplace. Right. Would you be amenable to entering into what we call in the trademark world a coexistence agreement? It's just an agreement that says, I won't sell books, you won't be selling my type of products, and it puts parameters into it how we can coexist in the marketplaces without having any problems.
Right.
That's often done. Sometimes that's done to overcome the trademark office saying they're confusing. You could have both sides do a coexistence agreement, and most of the time the trademark office backs down. So that's probably the conversation to be had. But right. To answer any more specifically, I would have to know all the details.
Sure. I think too, if they're selling apparel and this other person's selling books, maybe they could partner up and
cross promote, have a tie-in.
Exactly. Yeah, I'll create the apparel for your books, and
there you go, strategic alliance.
Exactly. Well, those are all the questions that I have for now. I didn't see any others come in through the Q&A for now. Well, that a lot of people are, of course, have asked for your information and maybe in touch with you here, and the folks that weren't able to join us today. I've heard from quite a few that weren't able to at the last minute. So,
right. Yeah. Folks, copyright is an entire semester of law school. So understand, we just kind of skipped across the surface. The only thing we can do in an hour's time is to sensitize you about some issues and things you need to think about in both copyright realm and trademark realm. But yeah, I'm around. You have my information, and know this: if you contact me with just a quick question, you're not going to be charged. However, if you ask me to either draft something or review something or file something, in other words, you're deploying me to do something for you, we'll talk about what that would be and all of that. But don't feel like if you're just going to shoot me an email and ask me a quick question, you're on the meter. You are not.
We appreciate that about you. And yeah, I appreciate everybody joining us today. This has been great. As you said, Russ, I think this is just the tip of the larger iceberg that we could chip away at. So certainly, you know, as we're, for some of us, kind of starting the new year, even in March, and things are starting to pick up, we would love to have you back to jump into this even more, and have those of you joining us today come back in to talk about that. We're getting a lot of thank yous today, of course, very helpful, great information. So Russ, we appreciate you and this, and
My pleasure.
you know, absolutely, we'll see you back here. So thank you so much.
Bye all.
All right, take care. Bye, everybody.